which the favorite word of defendants in answering the lawsuit is deny, 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 right? Anything you admit, you're stuck with that. So again, you don't want to admit a whole bunch of things, especially anything that could really help the defendant lose the case. But, basic things like the defendant is a corporation existing in the laws of the state of Maryland, if that's true, obviously you have to admit, right? You can't just deny things that really are true. So you try to, lawyers have little ways of playing with the words, denied as written, denied because I don't have enough information to know whether it's true or not, that kind of thing. And you also would state in your answer what we call affirmative defenses. So for example, if the suit is a suit on a promissory note, and you are the defendant, and you have paid the plaintiff every penny that the plaintiff is owed under that promissory note, then that's going to be one of your affirmative defenses. I don't know why you're suing me, because I paid you everything, okay? Another affirmative defense would be what we call in Louisiana prescription, just like it's spelled for medication. Prescription in other states, anybody know what we call these laws in other states? Statutes of limitations. Those are the laws that tell people how long you have to bring your lawsuit. How long do most of you think you have to bring a lawsuit after something happens to you? Yeah, most people think it's a year, and that is true for certain kinds of cases. So for like personal injury cases, bodily injury, property damage, motor vehicle accidents, you go in for surgery and the doctor cuts off the wrong leg, oops, malpractice, right? That's a negligence action. You have 1 year from the date the bad thing happens to bring your suit. But if you and I were involved in a business and we had a contract between us and one of us breached the contract and the other one sues, you actually have 10 years under Louisiana law to bring a suit for breach of contract. 10 years from the breach, from the date that the breach of contract took place. Suits on a promissory note, you have 5 years from the date of the last payment, which presumably was not supposed to be the last payment. From the date the person who owes you the money stops paying you, you have 5 years. On open account, credit card bills and stuff, 3 years to bring a suit. So it really does vary. But again, that would be another affirmative defense. You brought your suit too late. So all of that gets laid out. And of course, defendants can bring in other people. Defendants can say, well, the plaintiff sued me, but if I'm liable to the plaintiff, there are other people who are liable to me. And so that defendant can bring cross-claims, bring new parties in that the defendant says, if I'm found liable to the plaintiff, then these third parties here, these guys are liable to me. So you can do all of that kind of stuff. So once all of that is out of the way, once the answer has been filed and all of that, the next and probably the most important phase of the trial is the middle phase that we call discovery. So what that's about is the parties attempt to discover more information about each other's case. So the defendant is going to want to know more details about the plaintiff's claims, and the plaintiff is going to want to know, how is the defendant going to defend this lawsuit? What are they going to raise as their defenses? So you do that first in written form. Each side, plaintiff and defendant, submits to the other side, to the other party, a set of interrogatories, very fancy word for questions, a set of requests for reduction of documents where, again, you're asking the other side, produce all documents that relate to your claim or your defense. Requests for admissions, don't worry about that. It's just know that it is another written form of discovery. So requests for admissions would be things like, please admit or deny that on such and such a date you were involved in a motor vehicle accident at Clearview Parkway and Veterans Highway. Admit or deny it. okay? And you can go down the list of those things, and anything that you can get the other side to admit, that doesn't then have to be proven at trial, because they admitted it in their request for admissions, okay? So once the written discovery is out of the way, and those forms I sent around a couple of classes ago, I guess, had some interrogatories and request for production of documents along with the answers attached to them, or as part of that handout, so hopefully you got to look at that a bit. Once the written discovery is done, depositions begin. You don't have to wait till all written discovery is sent out and also answered, but typically that's what you do, because usually when you take the deposition of a person, you're not going to get 2 bites at that apple. Usually, if you're going to take the deposition of the defendant, it's going to take the deposition of the plaintiff. You're going to want to be as fully prepared as you possibly can. You're going to want to know as much at that time you take the plaintiff's deposition. The defense attorney is going to want to know as much as he possibly can know about the case ahead of time, so that he can ask appropriate questions, and questions that may help him defend the case. Now, depositions are done face-to-face usually. They can be done through video and other means, but usually they're face-to-face. And the party whose deposition is going to be taken has to show up at a certain day, certain time. There will be a court reporter present, just like there is a court reporter present in every courtroom anytime anything goes on. And that court reporter sits there and takes down, again, every word that everyone says. It's no different at a deposition. The court reporter is there. She records all questions asked by the attorney taking the deposition, and she records all answers by the witness. The court reporter also records all documents or exhibits that are handed to the person whose deposition is being taken and that person is asked about. After the deposition, and the witness, whoever is answering the questions at the live deposition, the witness is under oath, just like you would be if you were testifying at trial. Okay, so the witness is under oath, sworn to tell the truth, whole truth, nothing but the truth. Once the deposition is completed, the court reporters will ask both sides, do you want a copy of the deposition? What that means is, the court reporter, I took down everything everybody said, but I took it down in that squiggly little weird language that's on my little strange machine here. It ain't English, it's not any other recognizable language, right? It's like a shorthand. So if you want a copy of the deposition, I, the court reporter, have to go home or back to my office and type the squiggly, goopy stuff that I wrote into plain English in a transcript. Question, answer, etc., etc. Depositions can be, and often do kind of run up in costs. A 3 or 4 hour deposition will probably cost you $1,500 or so, just to have the deposition and to get a copy of the transcript. So you can see if you take 10 depositions, you're really like jacking up the cost, the expense. So you try not to take any that are really not absolutely necessary, but by the same token, nobody wants to go to trial not knowing half of what you should know about the other side's case, right? So the best way to find out what's the defense going to argue, what are their defenses going to be, and the defendant wants to find out what all is the plaintiff going to say, who are going to be her witnesses, what are these people going to testify to. The best way to do that oftentimes is to take depositions of the witnesses. Before everything is over with, each side will have been required by the court to tell the other side who their likely witnesses at trial will be. And so that's how you kind of make the decision about whether or not you want to take a deposition. In the interrogatories, each side asks the other, give me a list of the people who are going to be, that you think will be witnesses for you at trial, and give me a brief summary of what you expect each of those people to testify to. What are they going to talk about? That, again, is what really assists the lawyer for the other side trying to decide, do I take this person's deposition, or can I afford to wing it with this this guy and take a few more over here that are more important witnesses. So once discovery is complete, there are a couple of motions that can be filed, but the only one you're responsible for purposes of the test is a motion for summary judgment. So in the law, summary means quick. Summary means fast. So what this is about, usually motions for summary judgment most often are filed by defendants. They can be filed by plaintiffs, but often it's defendants who file them, and they often, most typically file them after discovery is complete. And this is what a motion for summary judgment does. It says to the judge, we've done all of our discovery. I've gotten all the plaintiff's answers to my interrogatories. I've seen all of the documents the plaintiff's going to introduce at trial. I did request for admissions. I took her deposition. I took the depositions of 3 of her most important witnesses. And guess what, Judge? Under the law, given what the law says she has to prove in order to win her case, and now I know what her evidence is through this means, she can't prove her case. I took her witnesses' depositions. I've seen her documents. I know what the plaintiff is going to argue, and she's missing element 2 and element 3. She can't prove exactly what she said she's claiming. So, because she can't prove it, throw her case out, dismiss her lawsuit, and let's not waste the court's time or taxpayer money having a full-blown trial. Let's just shut it down now. No need to have a trial because you, judge, and we now know that she can't prove her case anyway. It's a waste of time. The judge can grant that or deny it. If the judge grants the motion for summary judgment, plaintiff is out of court. And the only thing the plaintiff can do from that point is appeal to a higher court and say, please tell the trial judge that he should not have thrown my case out. He should have let me go to trial. If they deny, if the court denies the motion for summary judgment, then we're going to trial. The denial of a motion for summary judgment gets the defendant all worked up, because now the defendant knows he lost his attempt to get the case thrown out early, right? Now he's going to trial, oftentimes in front of a jury. Uh-oh, the sky is the limit, right? Plaintiffs, of course, hate it when the courts grant these motions because you've been working for all these months, sometimes years, to get the case all worked up to go to trial, and now the judge pulls the rug out from under you and says, oh, no trial. You don't get your day in court to tell your sad story to the jury because you can't win. The standard for getting a motion for summary judgment granted by the court is the defendant, as I said, is usually the person who files it. The defendant has to say, Judge, we got all the facts, we know all of the plaintiff's proof, and there are no material facts. The word material in the law means what? Wherever you see it, material breach of contract, material fact, it means important, significant. So while, Judge, there may be little tiny unimportant facts that the two sides disagree on, as far as the material facts, the important facts that the plaintiff has to prove to win her case, there is no dispute among the parties. Here's what her witnesses say. They didn't say what she wanted them to say. They actually testified in a way that favors the defendant. So there are no big issues that are in dispute. Her witnesses don't contradict the defendant's witnesses. We're not arguing about anything. So throw the whole thing out and let's get on. Okay? So assuming that the motion for summary judgment is denied, where we go from there, of course, is to trial. So I'm going to kind of walk you through step by step how trials operate and what goes on here, there, and everywhere, and then we'll work that to conclusion. And I only have about 15-20 minutes to talk about Chapter 3, as I to y'all, so we're gonna finish 2, and then you might have to bear with me for a couple of minutes to, so I can tell you what to study from chapter 3. It's not very much, and it's self-explanatory in the text, so I will let you know that once we get done with this. So, we're going to trial. So, let's assume that it's going to be a jury trial. We think of juries as always being composed of 12 people, but in some cases it can be 6, in some other cases it can be 9. I've seen some where it's 10. It's kind of squirrely, and I'm not really sure who decides what number is the appropriate number. But for the most part, we're going to go ahead and deal with, for the most part, there are 12-person juries, and we're going to talk about that. So, if you're the plaintiff or the defendant, either party can ask for a jury as opposed to a judge trial. Whoever requests the jury pays for the jury. So I just filed the lawsuit. I may have mentioned this to you guys. I just filed one last Friday. And we went back and forth as to whether or not we wanted to ask for a jury in the lawsuit itself. Because you can ask for a jury a little bit later in the process, but you don't always get it when you ask for it later in the process. So the kind of case I was filing, I'm representing the plaintiff, and I absolutely wanted the jury. So we didn't want to take a chance. My client said, put the request for the jury in the petition. So guess what it cost to file that? In total, it cost $1,432 to file a lawsuit, just to file. We could have cut it down to about $600 if we had cut out the jury request. The jury request added $780 to the cost of filing it. Then the party who asked for the jury is going to have to come up with the bucks when you get close to trial to pay the jury. Jurors have to be given a per diem, a stipend, if you will, for showing up in court. So you got to come up with all of that as well. So to select the jury, the process of jury selection is known in the law as voir dire. What this process is, in federal court, the judge conducts voir dire. In state court, the lawyers do it. And this is the process where I'm going to use state court and the lawyers asking the questions. This is the process where the lawyers for each side get to have some input into who actually ends up being a member of the jury on this case. But before they make that decision, they get to ask a whole bunch of questions of these potential jury members. Anybody here ever served on a jury? Oh yeah, you know what I'm talking about, huh? Did you actually serve?
Well, it took them 3 days for them to pick us, and then they had already settled it.
Okay, yeah, that's what makes people love lawyers and love the law. Lisa, how about you?
I served.
You served? What kind of case?
It was a medical case. Basically, this lady went in and said she was having some issues with her back, and the doctor suggested doing basically like an acupuncture type procedure, and she claimed that she
didn't
got
go
a
well.
punctured lung
Okay.
from it.
So medical malpractice action.
Yeah.
What court?
Uh,
Orleans, Jefferson,
no,
Federal?
uh,
So where?
civil?
Civil court. Yeah. What? Tell me the location.
I think it was in Gretna.
Okay, 24th, yeah. Civil court, 24th Judicial District Court. That's trial court in Gretna, state trial court. How about yours? Criminal. Fun. 7 days. What kind of case?
Multiple charges. Total charges were about 10 charges, 2 offenders, ranging from racketeering to drug possession, weapon possession, and murder.
Okay, well, there's a jam-packed action trial for you, right? Nobody getting bored during that trial. Lord have mercy. It went the whole 7 days? who want to serve in that process, and it is, among many others, a prime duty of being a citizen of this country. And I know nobody likes to do it because you have to stay away from work and you got all these other issues. You might have kids at home. If the judge keeps you to 10 o'clock at night, you got all kinds of things you got to deal with. But for every one of you guys who gets off of serving a jury, somebody else comes on. And they may not be people who are particularly interested in justice or deciding the case on the facts. Sometimes it's, people who otherwise stay home all day and watch soap operas. Where they can get a little cash from going down to the courthouse and serving. So you want people who are involved in their communities, people who are citizens, who think. That's what you want on your jury. So the kinds of questions the judge or the lawyers ask in voir dire, what the lawyers are trying to do is to find anybody who might be prejudiced or biased in favor of one party or the other. So if it's a criminal case, and it's a first-degree murder case, and the district attorney is going to ask for the death penalty if the person is convicted, the district attorney is going to want to ask a lot of questions on voir dire about individual